Terry Magedy, the chair of our Elder Law Committee for the Trust and Estate section of the Hills Bar Association. And it's great to have everybody in the webcast audience. The first thing I do is thank our sponsors because that's showing the proper appreciation for the people who make things happen. And so our sponsors are, you'll see them on the screen shortly. First, we have Nancy Sanborn and Brian Joy from the Sanborn team. They're real estate brokers and experts who work in our space, conservatorships, trusts, probates, and they've been our sponsor for many years. So thank you, Nancy and Brian and all the people at Sanborn team. The next folks, I'm going to say them together because really they're part of the same group. Bond Services of California and Liberty Mutual, the underwriter. If you work in the probate field, you know them because they provide just like tremendous service to all the attorneys in our space, probates, conservatorships, all the matters dealing with court services, and there's tremendous. I mean, they're really they make it. They make things happen for all the attorneys. They provide like necessary support for all of us. So thank you guys for being our sponsors, Bond Services of California and underwriter, Liberty Mutual, surety. Now, a California title company, a title company who also specializes in our space, probates, conservatorships, trusts. So thank you very much for being a sponsor. It's good to have a title company that specializes in our field to help us. And finally, Pickford Escrow Company, another player who works with us in our special areas. I'll repeat them: probates, trusts, conservatorships, just any matters that deal with the court and escrows. So it's great to have people who know our business. So thank you all for being our sponsors. And you'll pick up something. There'll be something at the end about getting credit for today's seminar. I believe something sent out to you guys afterwards. But now our speaker, Anil Chakra, someone who's went from a professional friend to a friend. I can't say enough good things about Anil. I've worked with Anil on a number of fiduciary matters, and where he is representing the fiduciary, and I'm representing the fiduciary too. And it's tremendous working with him. Somebody that cares, has the expertise, and in this industry gives you the straight scoop because everyone doesn't sometimes. So it has just been a pleasure dealing with, working with Anil over the many years. And, he'll explain more about our program today, but the program really it's so important because it's a step beyond our legal parameters. It's everyone who's on the Zoom who's an attorney may do documents, may administer documents, may deal with documents, but there's a whole other aspect of our world of planning for people with disabilities, administering estates for people with disabilities, and in the special needs world that is not strictly legal. And so I'm going to turn it over to Anil. And I just heard, wait a minute, I got to share big news. I forgot, I should have shared this. For the second year in a row, Beverly Hills Bar was named the top CLE education provider in the state of California. The top, and that's 2 years in a row. So we're part of a great outfit here. But and with that, I'm going to turn over the program to help us navigate in the world of special needs. A real expert and a friend, Anil Chakra. Anil, I'll now turn the program over to you, and I'm going to pop off. Looking forward to hearing everything.
Thank you, Terry. And thank you to all of you. Got big shoes to fill today, considering that accolade you just got. Congratulations being number one 2 years in a row. And with that, let me say good afternoon and thank you to the Beverly Hills Bar Association and especially Terry for having me. Let me start where it's useful. I'm a financial advisor, and I spend a lot of my time on exactly planning this audience, on the planning that this audience sees from the legal side. So think of the next 45 minutes as the financial structure that has to be built around the documents you draft, because the documents and the money are two sides of the same coin. Get one right and not the other, and the whole thing gets shortchanged. Sorry for the euphemisms, but my intern's pretty funny. One piece of housekeeping up front, and then I'll just start sharing the screen to go into the slides, and I'll leave this part alone after that, is that obviously I'm not a lawyer, not a tax advisor. So nothing today is, as such, would be necessarily legal or tax advice. I have to say that for our compliance. For those, your clients rely on counsel, meaning you, and of course, a CPA. The strategies I will reference may not be suitable for every client. They can lose value. There is no guarantees. They're not guaranteed. That's the standard caveat, and it's the last time I'm going to dwell on it, so let's move on. Let me share the screen. There we go. One moment. Thank you for your patience. Okay. Quick word on who I am. As Terry was mentioning, my name is Anil Chatra. I am a Senior Vice President and Financial Advisor here at Morgan Stanley. And a meaningful part of my practice is built around families planning across more than one lifetime. And that's going to be a key point here, including families where a child, a spouse, or a parent has a disability. And you might fairly wonder what a financial planning hour has to do with your practice. Here's my honest answer, and it's the thread I'm going to pull all the way through in this area. Your work product and the financial plan are really the same object viewed from two angles. A beautifully drafted trust that gets funded the wrong way still fails. A flawless estate plan undone by a single well-meant gift still fails. And when that happens, and it tends to happen quietly, years later, long after the engagement closed, and the family's first question is whether anyone saw it coming. The next 45 minutes are about making sure the answer can be yes. That's good for the families you serve. It happens to be good for you too. Slide 2, excuse me. Okay. One framing note before we get into the structure, and it's worth saying out loud rather than just leaving on the screen. Disability is a broad term. It takes many forms, and every family situation is genuinely different. That should be no surprise. Everything I'm going to offer today is an idea to consider. It's a menu, not a prescription. Each family does what works for them. For you, it's not a soft disclaimer. It's candidly the business reality. There is no form to fill out here, no clean template that fits the next client through the door, which is exactly why your judgment is the expensive part, the one that really makes it hit home. And why in this corner of planning, a coordinated team tends to outperform any single professional working alone. Look at the scale of this. And this is really powerful, I believe. Roughly 1 in 4 adults in the United States, about 27%, have some type of disability. And before I continue my prepared remarks, I really want that to sink in. 1 in 4. Nearly 10 million Americans are participating in the workforce with a disability. And in the 2021-2022 school year, about 7.3 million kids between the age of 6 and 18, or K through 12 students, were disabled. About 15% of enrollment. But here's the number that I'd flag for a room of attorneys, or in this case, a virtual room of attorneys. 80% of disabilities are acquired between ages of 18 and 64. Most disability is not present at birth. It arrives midlife, mid-career, mid-marriage, mid-plan. The estate planning client you met 5 years ago with the tidy file and the straightforward plan, it can become a special needs planning matter after one diagnosis or one, God forbid, accident. There's also an employment gap. This is heartbreaking here. About 23% of employment rate for people with disabilities. Only 23%. 66% of people without disability are employed as such. Translation, and this is the key point, when a disability arrives, household income often fails at the very moment expenses are going to climb, and not just temporarily. And it spans categories: developmental, behavioral, physical, learning, mental health. Different facts, different professionals, but the same planning skeleton underneath every one of them. So when I describe a structure today, resist the urge to file it under, that's a niche. On these numbers that I'm showing you, it's not a niche. It's a quarter of the adults you'll ever advise. And it's a meaningful share, of the families whose estate plans you're ever going to draft. Next slide. Yeah, all right, just the agenda. Here's the route we're going to take. We'll start with building a plan, emergency fund. I'm going to think about insurance, and then go on to estate planning, where I mostly hand the wheel to you. Then government benefits, which is where small missteps will end up doing outsized damage. And then the bottom line, 6 stops. I'll try to leave us some breathing room at the end for Q&A, but depending how long this goes. All right. We're building a plan here. This is the foundation before any document gets drafted. I want to walk through this as a timeline because timing is where this planning is going to live or die. At birth, a family, is beginning a new journey with a different set of challenges. The immediate items are early intervention, therapies, and doctor visits, and already estate planning documents, a will, special needs trust, powers of attorney, drafted with an attorney who specializes in special needs estate law, like my good friend Terry. No, I'm not trying to plug you, Terry, but I do love you. And that specialization matters. A generalist drafting in this area with the best of intentions can still produce a document that fails a benefits test that the family didn't even know existed. The family at this stage is also looking at Medicaid eligibility. And I'll be candid with you, at finding other parents and support groups, because the overwhelm that they feel, I've seen it myself, it's real. And the isolation they feel, it's real, especially if they have to make rush decisions at the time. The other parents and support groups part is just as important, in my opinion, as a financial advisor, a CPA, and attorney. By age 3, you're in a period of growth and change, and a new alphabet arrives. IDEA, FAPE, IEP. IEP is something that I'm personally had to deal with for both my children. 504 plans. 2 items on this part of the timeline to zero flag. First, begin the memorandum of intent. Second, and I'm going to read this one twice. Be careful, and please, this is so important. Be careful not to open any accounts in the loved one's names. A well-meaning grandparent who opens a savings account for the child can quietly compromise benefits eligibility before that child is old enough to spell the word eligibility. It's tragic at times. The professional who says that sentence that I just gave you early earns their fee many times over. That sentence is not in the trust document, it's in the conversation around it. And by age 14, the question gets bigger. Is there a vision for this child's future and a plan to fund it? What about the higher education? How does college planning for the neurotypical sibling fit alongside it? And it's time to review the estate plan and the special needs trust provisions and to start investing correctly for what really will be multiple lifetimes of income that will be necessary. At age 18, the door to federal benefits opens and a clock starts. The watchouts are you maximizing every available benefit? How do you protect them going forward? Given asset limits as low as $2,000 on certain programs, a figure we'll pin down precisely later. And I want to underline the importance of age 22. No time for procrastination. This is also where families weigh a court-appointed arrangement against powers of attorney. And the right term for that arrangement varies by state, so I'll let you supply it. And consider alternative insurance strategies. And then the memorandum of intent will continue. From 22 and beyond, the question becomes quality of life, housing options, who provides continued support, and bluntly, where the money comes from. This is where the enable account gets evaluated and where grandparents might be able to help and where the family tries to answer the hardest questions on the slide. How much does my loved one actually need? I've read articles in the past where those even without disabilities from birth to 18 would need $1 million, just to 18. At retirement, planning becomes multi-person. More than one lifetime of income, choosing when to start Social Security, and a question most retirement plans never ask: what if mom or dad themselves need lifetime care? And then the part no one wants to discuss, the parents' debts, as that's obviously one of the most difficult parts of the conversation. Is the special needs trust funding adequately? What are the tax ramifications on the estate? How do you equalize among all the heirs? Will there be enough for the siblings? Notice that every one of these questions is a question you can get asked at the drafting table. And the honest answer depends on whether the money was managed correctly for the 20 years before anyone sat down to draft. All right, structuring the plan. So how do you structure all of that without drowning? The cleanest way to organize all of it is around one overarching support plan. How the family manages care today and as the situation evolves. Resting on 4 pillars: preparing for the unexpected, education needs, estate structure, and finally, government benefits. Those 4 pillars are the rest of my talk. Hold on to them, that's the map. And notice the hierarchy. The support plan sits at the top. It's as literally as the umbrella. And the 4 technical pillars hang underneath it. Think of it more tactical versus strategy. The documents and the accounts serve the care plan, not the other way around. When I see plans go wrong, it's often because someone optimized a pillar in isolation and lost sight of the umbrella it was supposed to be holding up. So it starts somewhere unglamorous, a budget. We would calculate income, track current expenses, separate needs from wants. That's not an easy thing to do at times. In the context of the family's goals, set the budget, and then the step everyone skips, sticking with it, meaning monitoring this plan, and then adjusting as needed. How many times a plan is made and it's not monitored? More often than I care to admit. The key point on this slide is the one tailored to these families. Budget for the expenses other households don't carry. Medical copays, specialized transportation, in-home assistance. These aren't line items that disappear next year. And this, again, heartbreaking, these are permanent. It's permanent. And they belong in the plan from day one for that reason. There are real tools here. The U.S. Department of Labor has an employment toolkit An ABLE account offers a tax advantage way for eligible individuals to save for qualified disability expenses. An approved plan to achieve self-support, or a PASS, may let someone set aside money toward a work goal while keeping SSI eligibility. Trusts can pay for expenses that supplement benefits, and they have to be administered carefully, especially around food and shelter, because those payments can affect SSI. And 529 plans, they grow income tax free. They grow, they grow capital gains tax free as well, with distributions for qualified higher education expense free from federal income tax. That one I'm very personally familiar with for my own children. I'll say the careful thing here though, because I have to, and because honestly it's true. The tax treatment of any of these depends on specifics I'm not going to opine on. But take the 529 as one example. Its program disclosure carries the real detail on investment options, risks, fees, and tax consequences, and that it should be read carefully before investing. That's a conversation for the CPA, ideally one with special needs expertise. And what I would take away is actually simpler. There's more than one tax-aware vehicle here, each with its own rules and its own trapdoors. So the choice among them is deliberate, and it's a planning decision, and it's not a default. Educational support. Educational needs vary enormously, but the structures are fairly stable. Early intervention programs, individualized IEPs, individual education programs, specialized private education, mental and physical therapy, and 504 plans. I won't walk through the mechanics. That's a well-trodden ground in this room. But I will raise them because each one carries a cost and a timeline, and both have to land in the financial plan rather than ambush it later. 12, there we go. This is the slide I'd put on the wall. Around the family sits a network of 6. There's a social support network, other families living with the same disability, sharing experience and information, which sounds soft, and this goes back to what I said before about a support mechanism. But until you watched it keep a parent functional through a hard year, you may not really realize how much that support mechanism is needed. I've seen it. Terry has seen it. There's a social worker and a medical team providing care and treatment recommendations. There's an accountant who's genuinely versed in disability issues, specifically the tax credits and the deductions that reduce liability. There's an estate planning attorney who specializes in creating the estate and trust documents that protect assets set aside for a person with a disability. And there's a financial advisor whose job is to make certain the family's plans are coordinated and progressing toward their goals. Here's what I want you to take notice about this diagram, though, and it's the quiet thread running through this whole talk. I said it before, and I'll say it again here. No single seat at that table can catch everything. That's why a team is necessary. You can draft a flawless trust and never see the savings account a relative opened across town. That's happened. The accountant can optimize a return and never know the housing situation changed. The financial advisor can manage the money beautifully and still miss a benefits deadline if no one ever mentioned it. The protection in this picture doesn't come from any one expert being brilliant. It comes from each of the seats talking to each other. In ordinary planning, the coordination is a nicety. It's a nice to have. But in this line of work, coordination is the mechanism by which good work stays good after everyone has left the room. And it's how watching gets shared rather than resting on one person or one professional's shoulders. And not all of this is financial. Care is an ongoing process that gets more complex over time, and transparent conversations help everyone. The immediate questions: what care is needed now? Do the living or working arrangements need adjusting? What has to change today? The longer term ones: will the type of care change? Are there trusted resources to help? Is there an estate plan? Is it current? Will the ability to work change over time? You'll notice the money questions and the human questions are essentially the same questions. It's not a coincidence that's the case. Which brings us to the least exciting and most protective idea in financial planning, the emergency fund. All right, look at the gap between intention and reality. 89% of US adults say they need at least 3 months of expenses saved to feel comfortable. And I don't mean invested somewhere in some stocks or bonds. I'm saying 3 months in a treasury, 3 months, 6-month treasury, getting them 3.7 to 3.8% these days right now, or actually a little bit higher. Only 44% can actually have it, this 3 month of expenses saved up. 36% are trying to do 2 hard things at once: pay down debt and build savings. I can't tell you the number of times I've run across new clients who have credit cards that are charging them 24% a year. There are 5 kinds of financial emergency: income changes, home expenses, a medical emergency, transportation challenges, and insurance changes. Read that list through the lens of a family managing a disability, and you'll notice something. Every one of those 5 is more likely to occur and more expensive than someone without a disability when it does. The emergency fund isn't a caution for these families, it's realism. The arithmetic is simple. Average monthly expenses times 6 for 6 months minus existing liquid savings equals the emergency fund balance still needed. The target is 3 to 6 months of living expenses. And for these families, that explicitly includes enough to cover medical supplies and medications. An emergency fund is money saved and set aside before the emergency. Here's the thing, not after, before. The whole value in all of this is before. And I'd connect this back to the estate planning you'll do later in any engagement. A family without a cushion is a family that is, in a hard month, maybe tempted to reach into the wrong account, to tap an asset that should have stayed untouched, creating penalties potentially, or to accept help in a form that quietly trips up a benefit threshold. The emergency fund isn't only about weathering a storm, it's about not being forced into a move that unravels the careful structure that everyone built, and it will happen without it. Liquidity here is a form of protection for the plan itself, but also mental well-being for those who are trying to care for the one who's disabled. Insurance. This is the safety net under the plan. Strip insurance down, and it's simple. It's a safety net that helps protect a family financially. You pay a fee to an insurer, and in exchange, they pay for qualified damages or services to the insured or object over a predetermined period. It's easy to describe. The art, as always, is matching the right coverage to the right risk and not discovering a mismatch at the time of a claim. God forbid. An insurance overview. Insurance overview. So there's 4 categories, and I'll give you the load-bearing details on each. Medical and health insurance covers medical expenses and preventive care, but it rarely covers 100% of cost. So families should plan for the rest. 2 items worth holding: if a plan covers more than one person, there may be a separate deductible for each individual, and dependents can generally stay on a parent's plan until age 26, something that my 20-year-old loves to remind me of. A CPA with a special needs planning expertise is the right person for the tax credits and deductions around all of this. Disability insurance replaces income when someone can't work. Long-term coverage kicks in for absence of 6 months or more and can run to retirement. Short-term covers a shorter window, typically 3 to 6 months. Two honest caveats. It generally does not replace 100% of gross income, so plan for a gap. And tax treatment depends on how the premiums were paid. Often, if premiums are paid with after-tax dollars, benefits may be received tax-free, but it's fact-specific. Life insurance can be a key part of estate planning. Funeral and final medical costs, paying off debt, replacing income, future educational costs, or estate taxes. Term coverage runs a set period, usually between 10 and 30 years. Permanent coverage lasts the policyholder's life. Keep this one in mind because when we get to special needs trusts, life insurance is one of the ways a third-party trust gets funded. The insurance slide and the estate slide are talking to each other. And long-term care insurance covers extended help with activities of daily living. 4 dials to know: the monthly benefit amount, the benefit period, the elimination period, and the out-of-pocket window before benefits begins, because it could actually take a few months, if not more. Commonly 30 or 90 days, though. And an inflation protection rider. And these days, inflation is the key word we see in all of these headlines now. It can raise that inflation protection rider, that can raise the benefit over time for an added cost. So how much life insurance? The rough frame: financial obligations minus its expenses plus debt, minus liquid assets equals the coverage gap. As a general rule of thumb, people often aim for a policy paying 10 to 15 times annual income. What I've done for families is I've said, I usually say about 20 years. It's a little bit longer, depending on when the child may find themselves become self-sufficient. And that's, again, may be different for special needs. Needs vary with circumstances, and the instinct to speak with a professional is the right one, because in these families, the obligation side of that equation can stretch across a second lifetime, which is something I mentioned in the past. Estate planning. This is your home field. So here I'll mostly describe the financial machinery and let the law stay where it belongs with all of you. Okay. Estate planning is, at its core, a strategy to protect, manage, and distribute assets during and after a lifetime. Done well, a plan protects assets and prepares for the unexpected, advances the family goals, lets them invest in the people and causes they care about, and reduces unnecessary administrative expenses, taxes, and family conflict. And then a fifth line, and that's really the headline for this audience here, I believe. Consider carefully any plan that could jeopardize existing or future eligibility for benefits. In ordinary estate planning, a gift is generous. Here, that same generous gift can be the thing that breaks the plan. That inversion is the entire reason this is its own specialty. Estate structure. There are 3 ways to provide for a dependent. A direct gift or bequest is simple and costs nothing to set up, but the dependent may not be able to manage the assets, and the inheritance itself may cause ineligibility for benefits. I mentioned that earlier. A sibling gift or bequest is also simple and free, and it keeps the dependent's eligibility intact. But it depends entirely on that sibling's commitment. and those assets are exposed if that sibling faces litigation or divorce. Then there's the trust. It costs more, and it's worth being plain that estate planning attorney services are required. Absolutely. That's the reality, not my sales pitch. In exchange, the family's wishes can be carried out as intended, and family harmony is more likely to hold. Two of the three options on this slide trade simplicity for fragility. The third trade a little cost for durability. For a vulnerable beneficiary, durability is usually the whole point. And notice where the value sits. The first two columns are things a family can do at the kitchen table, and precisely because they're easy. That's where the avoidable disasters cluster. The third column is your column, the one that can't be improvised, the one that flatly requires a lawyer. So when a family compares a free option against a structured one and hesitates at the cost, the honest framing isn't expensive versus cheap. It's durable versus fragile. And a fragile plan for someone who can't advocate for themselves, it's not really a plan at all. And I am very somewhat emotional about this. It just doesn't make sense to be penny wise, pound foolish, in my opinion. That is a case you're better positioned to make, obviously, than I am. So let me take a step back from that. But it's true from where I sit too. Special needs trusts are the core tool, and there are three kinds. A first-party trust is funded with the beneficiary's own assets, and if the beneficiary later passes away, Medicaid may have a claim against what's left. That's the payback feature. A third-party trust is funded by someone other than the beneficiary or with life insurance on the life of the caregiver, and it carries no Medicaid payback. A pooled trust is run by a nonprofit that pools many beneficiaries' assets for investment while keeping a separate account for each of them. It's pooled, but they are separate. There's no mixing of assets. It's irrevocable. Assets can't be handed back to the donor. It can pay for things government benefits don't, like education, recreation, counseling, or medical attention beyond bare necessities. It can accept contributions from a range of sources, the beneficiary, family members, a will, or a life insurance policy, even court settlements. On death, the nonprofit usually retains a portion of any remainder, and Medicaid may still have a claim. And the management costs are typically lower than running a standalone trust, which is part of why a pooled option exists at all. All three share the same purpose: preserve access to government benefits while paying for the things that the benefits don't cover. Which one fits is a drafting decision. Yours, informed by where the money's coming from, which is partly mine. Considerations. So the checklist for setting one up. Consult an estate planning attorney, you guys and girls, with special needs expertise. Establish the trust for the person's benefit. Name a trustee actually capable of executing it. Fund it with liquid assets and use it for items government benefits don't cover. And then the trap, which is what I want to slow down on because it's a quiet one. If trust funds are used for the beneficiary's food or shelter, that can be treated as in-kind support and maintenance, ISM, which can reduce the SSI grant up to a cap or cost eligibility altogether. Picture it. A trustee acting with nothing but good intentions pays the beneficiary's rent, and the SSI check shrinks as a result. The document was drafted correctly, You did it right. The administration is where it went sideways. The drafting and the day-to-day both have to be right, and they're often handled by different people who never speak. This goes back to my original point where all the different parties involved, the team has to speak to each other. And one last reminder, these rules vary by state, which is I'll leave with the people licensed to interpret them yourselves. Estate planning documents. The documents set briefly. A letter of intent, the caregiver's guide to the dependent's medical history, care wishes, housing, and key contacts. A durable financial power of attorney, a healthcare directive, and for a dependent over 18, a healthcare proxy. The appointment of a guardian for a minor dependent, and a last will and/or revocable trust. There's a recurring fork for adulthood, a court-appointed protective agreement, arrangement, or supported decision-making through a power of attorney. And the label for that arrangement is one of those things that varies by state. Again, I leave to you. I flag the fork at all just because the choice carries financial consequences that'll ripple for decades. And it's the kind of question a family is grateful to be asked early than late. And a perspective check. Estate planning around a person with a disability is complex, but it's one part of a comprehensive plan for the whole family. Picture three overlapping circles: the individual with the disability, the other family members, sibling, if you will, and the family's personal goals, including retirement and philanthropy. The art is honoring the first circle without erasing the other two. Plans that protect the dependent but quietly bankrupt the parent's retirement or leave the siblings feeling like an afterthought, those aren't successful plans. It's just stating the obvious. They're not successful, they're unfinished. Government benefits. This is where the smallest details will carry the largest consequences. First, a reality check again, and I'll deliver it gently. Individuals bear most of the cost of long-term care. Government help exists, but it is limited. Medicare pays for up to 100 days of skilled nursing at an approved facility when conditions are met, and may cover intermittent home health care when a physician certifies that the patient is confined to home and needs nursing care. Social Security offers disability payments to people who can't perform substantial work because of a disability expected to last at least 12 months. And those disability benefits end when Social Security retirement benefits begin. So families can learn more about this at medicare.gov and at ssa.gov. The headline: do not assume the government is the plan. It is a thin layer under the plan that you will build. This is a useful summary table. I know you're going to get a copy of this PowerPoint, so but if there's any other questions, you can follow up later. This is a useful summary table. It's worth saving for reference. 4 federal programs with eligibility that generally turns on age 18. SSI turns on disability status, income and assets, and under 18, the parent's income and assets count too. SSDI turns on work credits on survivorship and can be available to a person whose disability began before age 22. Medicare generally requires 2 years of SSDI benefits first, and Medicaid flows to those who qualify for SSI plus state waiver programs. I won't recite every cell, but the age 18 line is worth making explicit because age 18 splits the whole table. Before 18, a parent's income and assets are pulled into the SSI calculation. After 18, the individual is largely assessed on their own. SSI may actually increase if the individual or parent starts receiving SSDI. And Medicare can come into play for certain dependents whose disability began before age 22. Typically after a period of SSDI benefits, again, very rule driven. And to enroll, the individual or the parent generally needs Social Security work credits in the past 3 years or to be receiving retirement benefits. Medicaid access varies with the personal situation and the state. That's no surprise. The point I lift off this slide is that there's there's 4 programs. These 4 programs interlock. The rules shift at 18, and they vary by state. If I were to bullet point that out. It's an easy place to make an expensive mistake by being slightly early, slightly late, or slightly over a threshold, and it will just amass itself over time and become a much bigger problem. Slightly is doing a lot of the work in that sentence. Here's one almost nobody sees coming. Social Security rules tied to marital status can reduce or affect benefits for otherwise eligible people with disabilities if they marry. This may be the only financial talk you'll attend where, should the couple get married, is partly a benefits eligibility question. I hope you don't run into that too often as such. But yeah, in this case, it's a benefits eligibility question. The guidance is to consult a tax advisor to weigh the impact before the wedding. And it notes that existing court-appointed arrangements may bear on the question too. Both of which I'm very content to just leave to the appropriate professionals on this. That's my purview. A smaller landmine on the same slide, cash gifts count as income in the month received and as an asset after that. So I'm going to say that again. Cash gifts count as an income in the month received, but then as an asset after that, in both Medicaid and in the SSI calculation. So even the wedding gifts need a plan. The practical move, couples should tell friends and family in advance how they prefer to receive the gifts. Romantic? No. Sorry. Protective? Very. Though my wife thinks I'm romantic, I hope still, after all these years. Slide 32 here. Discuss your plans with family members. Which brings us back to the relative with the checkbook. A well-meaning direct gift can quietly undo a family's planning. And here's exactly why. So that $2,000 figure is specific. It's the SSI countable resource limit, $2,000 for an individual, $3,000 for a couple. I want to be precise about that because it's a common misunderstanding to treat $2,000 as one universal line across every government program. It isn't. It's the SSI line. The other programs on the prior side, SSDI, Medicare, Medicaid, each have their own different rules. And for many families, SSI isn't even the binding constraint. So the real point isn't a magic number. It's that a gift that's harmless in an ordinary family can trip a specific threshold in this one. And which threshold depends on which benefits are in play. So hence, the fix is coordination. Go back to that over and over. Encourage family members to check with the lawyer, the financial advisor, the accountant, each with special needs expertise before making any specific gift. And the single most useful sentence on the slide, any gift or bequest in a will or a beneficiary designation should be directed to the special needs trust created for the person. Cannot stress that enough. Never, please, never to the individual individually. Never to the person, individually. Go to the special needs trust instead. That's the difference between your grandmother's generosity landing as a blessing and landing as a disqualifying event. Same money, Same intent. The plumbing is everything here. So let's bring it all together. The advice here is one word. 3 times I've said it now, if not more. Well, here on this slide it's 3 times, but I think I've said it much more than 3 times. The point is communicate. Start the conversations early because life moves fast. It's not slowing down. And it's far better to have a plan before you need it than to assemble one in a crisis. Please, before. The circles to bring in, a partner, parents, and or children, trusted friends, the professionals, and the care team. None of this works as a secret. The plans that hold are the ones that are said out loud, early to the right people. There's no need, there's no shames. There's no shame, there's just no secret. Communicate. This is the slide I'd ask you not to skip. People with disabilities can be particular targets for financial fraud and abuse, often from people they know. And here's the uncomfortable part. I'm going to be as direct as I can about it. The very roles created to protect them, powers of attorney, trustees, conservators, can sometimes be the financial advisors, can sometimes be the ones who exploit them. Sit with that for a second, please. Because underneath it, this is a slide about fiduciary responsibility. And that's worth naming plainly to this room. The instruments you draft to safeguard a vulnerable person concentrates enormous power in one set of hands. Most of the time, that's exactly right. But the answer to that risk isn't to trust less. It's to surround the arrangement with more eyes. Kind of reminds me of decentralization. It's a financial advisor. It's a CPA. It's an attorney. It's a mental health professional. Each able to watch for signs and step in. Here's where it touches your practice directly, and I'll say it once carefully. Many of you in this room aren't the fiduciaries yourself. You represent one. A trustee, an agent under a power of attorney, a family member who agreed to serve, often someone doing a good deed and quietly worried about getting it wrong. That person carries a real responsibility for a beneficiary who may not be able to speak up for themselves. When a financial advisor takes on management of those assets in a fiduciary capacity, which is what we do, it's not a sales pitch, it's true. We do take on those assets in a fiduciary capacity. That responsibility stops resting on the trustee's shoulders alone. It becomes shared. We do right by the beneficiary, which is the whole point. And in doing so, we also stand alongside the fiduciary, your client, rather than leaving them out there by themselves. I cannot stress this one again enough as well. This is not a sales line. This is just facts. It's just how a coordinated, accountable structure actually distributes the weight of responsibility. The practical close on the slide is report. Financial scams go to the ftc.gov/complaint. And depending on the situation, to Adult Protective Services, the Disabilities Rights Fund, or the Long-Term Care Ombudsman. The checklist. Promise we're almost done. Plan for the future care costs. Do the estate planning. Understand the government benefits. Consider life insurance to cover future care. Think through education planning, including whether a 529 fits. Don't forget the family's own retirement. Get legal expertise for the complex roles and work with a financial advisor who specializes in this area. 8 items. And the thing I'll leave you with is that No one professional owns all eight. We're going back to that again. The families who come through this well aren't the ones who found a single brilliant advisor, legal, accounting, or financial. They're the ones whose advisors talked to each other, where the attorney's documents, the accountant's returns, and the financial plan built by the financial advisor were built as one structure instead of three. Your work and mine are the same structure seen from two sides. I said that before. When they're built together, the client is generally protected, and we are sharing in the fiduciary liability with you, the financial advisor, with you, the attorneys, with the fiduciary, excuse me. And the good work each of us does, it actually holds up over decades because it has to. So just closing up here then. If today did its job, hopefully, you'll leave seeing that the financial scaffolding that sits around the document you draft and why I think the best outcomes for your clients come from a coordinated team rather than any of us working solo. I'd value the chance to be that financial seat at the table for the families you serve. That's my one little pitch. Let me leave you with a single image I'd want to stick. Everything we covered, the timeline, the emergency fund, the insurance, the trusts, the benefits, the document set, it's one structure. And you and my team and I are each looking at it from one side. The families who come through this well are not the ones who found a single brilliant professional. They're the ones whose professionals were in contact, monitoring the plan in place so that a funding decision and a drafting decision and a tax decision were made as one decision instead of three separate ones, all coordinated. That coordination is what protects the beneficiary. And it also quietly, what stands behind the fiduciary your client may be, so the person who agreed to do a good deed isn't carrying the weight or the worry alone. As I said at the top, none of this was legal or tax advice for those your clients have you, and they have their CPA. And the strategies referenced may not suit every client. They can lose value, and they're not necessarily guaranteed in returns. No one ever should say that. With that, I think we have only about 2 minutes left, but if it's not time now, sorry, Terry, we could.
It's okay. That's okay. People, by the way, fantastic program, Neil. How about this for the only question is, quote, excellent program, learned a great deal. Thanks. That's the question. And I think that goes for everybody. It's excellent. What great information to like really bring everything together that we do. Because all of us are, sometimes we're focused on our little niches, but what the program did is it casts a kind of a wide angle on everything. So we all get a great perspective. So Anil, thank you so much. I mean, people do have questions. They can
Yeah,
wait a minute, we only have 1 minute, but I was going to say right before we address, oh my God, we got thank yous. And then what I'm going to suggest, because we're at the 1:30 mark, all you have to do is type Anil's name in the internet, right? And you can get the email. And
let me give it right now, just in
I'm
case.
going to give the email right now. Take it down, folks, and you could email. Okay, here, and Neil's going to give it right now orally.
Sure. Let me start with my phone number. It's 310-443-0585. And my email address is Anil, ANIL, period, CHACHRA at ms.com, which stands obviously for Morgan Stanley. ms.com is easier.
Great, fantastic. And all the questions are great. Thank you. I love this program. That's the message. But one person said, "What about the client is functional adult with autism?" That's like a bigger, it's a bigger question. But you could talk to Anil directly about that. And I think it's 1:30. So
sorry, a little over.
I'll end with adding my thank you to that whole list of thank yous that have shown up on the Q&A. Great program, and really appreciate it. Thanks everybody here, and see you at the next bar program. Okay,
Take care. Bye-bye.
bye. Bye.